wherein the Supreme Court is the sole court that can be able to...
Presidential candidate Uhuru Kenyatta and running mate William Ruto will know whether their names will remain on the ballot next Thursday when the High Court gives its verdict on their eligibility to run. Their lawyers put up a spirited defense discounting concerns raised by members of 4 civil societies and dismissed the case as mere speculation. The Center for Policy and Conflict, who led fellow civil society groups in challenging their suitability for the top jobs, argued that the two face serious charges at the ICC that dent their credibility to lead the nation.
And so, under that Article 144...
But lawyers Evans Monari, Katwa Kigen and Kibe Mungai disputed the allegations, saying the ICC case would not hold water because the prosecution's star witness number 4 had withdrawn his evidence, admitting that he lied.
When you adjourn and you lay back in your chambers and you're reading that decision, your lordships will find reliance on a witness who is only identified as witness number 4. It is upon the evidence given by witness number 4 that that confirmation was given by the pre-trial chamber. The particular witness number 4 has been dropped as a witness because not only has he recanted his evidence, but he has said that the evidence that he gave to the International Criminal Court was false, was a fraud, and the embarrassment to the prosecution has led the prosecution to drop that particular witness.
The only objective criteria that has been set for purposes of determining whether somebody has integrity enough to hold a public office, either by way of appointment or by election, is either he has been convicted for a period of over 6 months and has exhausted his options for appeal, or has elected not to appeal. We submit that if you apply that objective criteria, the allegations made by the petitioners are completely speculative because they do not meet the minimum objective criteria that has been prescribed by the Constitution.
If a person seeking, in the effect of their submissions, to exclude a person from contesting a political office and does not bring themselves to the meaning of qualifications and disqualifications, no person has a discretion or has a prerogative to coin their own prejudicial terms like eligibility and suitability and purport that there is a legal dispute that can be based on such terminologies. The reliefs that are being sought were to be granted. It is not, the grievance would not just be Uhuru Kenyatta and William Ruto. It is the millions of Kenyans who are supporters of this party. It is the millions of Kenyans whose parties have nominated them as their candidates for the elections. And I submit that this court in exercising its jurisdictions must bear in mind the public interest of those millions of people whom, in effect, their rights of universal suffrage under Article 38 to meaningfully participate in the formation of the first government under the new constitutions would effectively be lost through a court order.
Candidates' argument was also supported by the Attorney General and the IEBC, who feel that the matter is beyond the High Court's jurisdiction. Interestingly, the court's decision will come a day after the two are summoned to make an appearance at the ICC. Reporting for Capital Online TV News, I'm Wambu Indonga.